Dear students, this slideshow's purpose, the sole purpose of this slideshow, is to assist you in the research assignment that is due on the 28th of September. The assignment is to critically discuss the application of the provisions of Section 36 of the Constitution of the Republic of South Africa 1996 in Freedom of Religion South Africa versus Minister of Justice and Constitutional Development and Others 2021 SA1CC. What do we see here? It's all about a recent judgment, Freedom of Religion, or FORSA, F-O-R-S-A. It's a judgment that was delivered in the Constitutional Court. That's what the CC is for. And what we need to investigate is how Section 36 of the Constitution was applied in this particular case. So what we immediately see is we will have two things happening here. Section 36 and this judgment. And now we have the instruction that it should be critically discussed. And what does that mean? And I'm just going to read from the action verbs in the model outcome document. Discussion requires that you comment on a matter in your own words. Discussion often also requires that two or more standpoints or possibilities be debated systematically. For example, to examine, analyze, and approach a case from different angles. And what does it mean to do so critically or to criticize something? Criticizing requires that a statement, argument, approach, view, etc. is judged. In criticizing, you point out certain positive or acceptable and negative or less acceptable concerns. Issues that you agree with and issues that you have your doubts about are indicated together with reasons. Criticizing does not imply finding fault with something, but differing or agreeing with certain views, arguments, or standpoints in a substantiated manner and giving your own opinion. Criticism always takes place on the grounds of certain criteria, values and principles within a certain context or against a certain background. So what will you do here? You will measure the judgment in freedom of religion against the provisions of Section 36. And that is what you are required to do. What did the court do in the particular case? How did it apply the provisions of Section 36? And then comes the evaluation or the criticizing of the court's method or the way in which the court approached the matter. This assignment should be submitted in the form of a typed paper. The style prescriptions of the Faculty of Law must be followed. It must be uploaded on IURI in PDF format. There must be a cover page and a detailed list of sources or bibliography. And the content of this assignment should not exceed 5 pages. So it may be more than 5 pages, but then the rest should be the cover page, the index, maybe a list of abbreviations if you wish, and the bibliography. But the text itself may not be longer than 5 pages. If you exceed the text, even by a sentence or two, if you exceed the 5 pages, you will be penalized by 5 marks per page. Please use additional legal sources. Textbooks, other cases, articles in legal journals. No Wikipedia, no websites of religious or political organizations. Please take care, visit the library's website and ask the librarian if you can't find anything. But there are lots of articles and cases on Section 36. And remember to submit before almost midnight on Monday the 28th. Why do we give the assessment grid? Why do we bother? We actually give it to tell you how to do the assignment. This should serve as a guideline how important certain things are and what weight you should attach to which aspect. So for 20 marks, you have to describe the events that led to the dispute. You must also identify the right or the rights in the bill that was or were allegedly infringed, and what was the legal measure under scrutiny. It means which rule of law was contested. And you need to identify all of this very clearly, very succinctly, and then continue to describe or summarize the limitation inquiry and the findings of the court in this regard. What does this mean? This means you have to explain how did the court conduct the inquiry, whether the legal measure was constitutional or not. How did the court approach this? Findings does not mean that you just copy and paste the order of the court. You have to go and explain step by step what was the finding on this issue, and then the next issue, and the next. And then, very importantly, is the evaluation of the limitation inquiry and findings. Just be aware here. It's not the evaluation of whether or not corporal punishment should be legal. It's not the evaluation of anything else, of the appeal, the permission or the leave to appeal or the costs ordered awarded, anything else but the limitation inquiry. You focus here on the limitation inquiry. And what you do is you evaluate. So you look to say what the court did correctly and what could the court have done better. And how do you say that? How do you get there? You need to go and read. You need to go and read a lot about the limitation inquiry so that you have other textbooks or articles or other cases to use to argue whether the court did this brilliantly or whether the court could have done it better. So for every point of criticism that you give, you have to substantiate it. You have to refer to a source or to explain why you make that particular assessment. You will then obviously have 30 marks for technical or the skills aspects. How do you use your language? Do you have a good line of argument throughout the assignment? Did you adhere to the style prescriptions? How is the presentation of the assignment? Did you properly use applicable legal sources? Important here, not News 24, not Wikipedia, not something you found on some political party or religious organization's website, but did you use legal sources? What are legal sources? Other cases, other laws, legal textbooks, and articles in legal journals. So before you start, what should you do? You have to work through the entire study unit on limitation of rights. If you're a 275 student, this is study unit 9. If you're a 223 student, it's study unit 2. You have to read the freedom of religion South Africa case, the case that this is about, at least twice, so that you have a proper grasp of the facts and the legal issues in contention. And then you need to start searching for additional sources, applicable, relevant, suitable, additional legal sources. And once you have found these, you need to start planning. Plan, plan, plan. Because you only have 5 pages and you need to cram a lot of information in there. We strongly advise that you don't take shortcuts. Do the work and do it correctly. And don't start writing without planning your structure, your layout, and your length. Regarding the structure, draft a framework. Remember to include an introduction and conclusion. And use the assessment grid as a guideline to assist you in what must be in there. And plan what goes where and how long each part should be. Because you now have all the material that was prescribed for study unit 9. You have the case itself. In other words, you have your textbook, you have the EFF case, you have the freedom of religion case already, and now you've also searched for additional sources that you will use. Plan what goes where. Don't start writing without an idea where you're going. You need to figure out first what you want to say and where you want to say it. Please don't use 3 or 4 pages to give a detailed account of the facts and the background and go into all sorts of irrelevant issues and try to cram the entire limitation inquiry and its evaluation into the last page or 2. So, getting back, don't ignore the mark allocation. Have a look at what is required and how the marks will be allocated. When you summarize the judgment and you explain how the court reached its verdict, use your own words. Do not copy text out of the fly note or the head note or part of the judgment. Explain how the court reasoned, how it reached its verdict. Don't just copy and paste the court order, because that doesn't tell us anything. That does not explain how the court came to its finding. You have to provide views. If you provide authors' views, for example, the views of the textbook authors on how Section 36 should be applied, use your own words. Don't just copy and paste. Don't just rely on unsubstantiated personal opinions. Use your sources. You have to demonstrate that you can find and use legal sources appropriately, and do that. How do you demonstrate it? By actually referring to those sources. On the point, on the matter of reference, you need to back up each statement of fact that you make by referring to a source. So if you say in case X this and this and this was found, you need to insert a footnote and you need to give the complete reference of case X and in which paragraph was that said. Or if you state that this is the view of author Smith, you need to have a reference, a footnote with a source, either a book or an article where Smith actually said what you are now alleging he or she said. Importantly, do not copy any part of a textbook, an article, a web page, or anybody else's work. Just don't. Do focus on the court's handling of the limitation inquiry or its application of Section 36. Don't go into a discussion of ancillary matters, for example, whether or why the party was granted leave to appeal, what the court's jurisdictional inquiry entailed, or the costs inquiry. That's not relevant for purposes of this assignment. You need to provide a legal evaluation of the application of Section 36. Please, not a religious or a psychological assessment of the desirability of corporal punishment. This is not required in this module. When you evaluate, please do provide positive and critical feedback on the court's application. What did the court do well? Where could the court have done better? And about what? About the application, or in the application of Section 36. This is not a discussion of the pros and cons of corporal punishment. Format-wise, use the law faculty's prescribed style. Please remember to paste the assessment grid on the very last page of your assignment after the bibliography. Please, please, please spell check and proofread before you submit. Save as and submit in PDF format. Don't exceed 5 pages, content-wise. Don't forget your cover page, your index, your bibliography. Do not try to cover up copy text by using synonym spinners. Please don't plead ignorance when you have copied text and we proceed with disciplinary inquiries and you face suspension. Most importantly, don't miss out on learning and regret taking shortcuts. Use this opportunity to hone your skills and enjoy what you are doing. And remember, you're always welcome to ask questions.